Hello and welcome friends to this fourth session in Unit 1. Up till now we have discussed the basics of advertising. Then we talked about its nature. We also discussed whether advertising is a science or an arts. We also talked about the various roles that advertising plays as far as the marketing function is concerned. Then we went on to discuss the key stakeholders who are part of the advertising world, and then we talked about the social aspects also. I hope you remember. In fact, as far as social aspects are concerned, I talked about the ethics in advertising also, and I gave you some examples, live examples from the advertising world. One of the example which I missed out was the last one. I talked about the surrogate advertising, but I actually missed out on this last one. Now what am I trying to show in this particular example? Please have a look. Now this is an ad for the Tough brand of shoes. However, you see the two models, and this was an ad which received quite a lot of comments from the general public, and the reason was that basically this is a Tough shoes ad. However, you see that the models are not dressed up at all. So these kind of advertisements which show characters which use sex appeals or which depict nudity, they are also not considered ethical. So this was one point which I missed out. You can have a detailed reading on this particular controversy, this particular controversial ad. This actually portrays two characters wearing nothing, but they have got a snake around them, and this is Mr. Milind Sonam, who used to be a supermodel at that point of time. So this particular ad attracted a lot of controversy at that point of time. And what I'm trying to tell you is that these kind of ads which display sex appeal, which are trying to make use of sex appeal or which show nudity, they are also considered unethical. Now let me move over to the legal aspects of advertising. We have discussed the social aspects. Now the time for us, the agenda for this particular session is to discuss the legal aspects. Now let's have a look. As far as the Consumer Protection Act 1986 is concerned, I hope you remember that we have discussed this in your second semester when we were basically going through business environment. So therein we had discussed Consumer Protection Act 1986, and I also hope that you remember now that it has very recently been replaced by another version, that is the Consumer Protection Act 2019. So we are taking up Consumer Protection Act 1986 because the same provision also are there in the recently refurbished act also. So the provision originally was there in the 1986 act, but the same provision has now been included in the 2019 act as well. So in Consumer Protection Act 1986, one particular thing, I hope you remember that it basically talked about unfair trade practices. So in Consumer Protection 1986, unfair trade practices have been described, and one of the descriptions says that unfair trade practices also include false claims. So you are making false claims which do not stand the scrutiny. So those kind of claims, if you are making about the quality of the product, if you are making these kind of claims about the quantity which is contained in a particular pack, if you are making a false claim about the grade, if you are making a false claim about what all does the product contain, the composition, if you are making a false claim about the style, about the warranty period or the conditions under which the warranty would apply, or about the price, all these, they were termed as unfair trade practices, and naturally they were not allowed under the act, right? Likewise, if you are making a wrong claim, a false claim about sponsorship or approval, what do we mean by this? If you are making a false claim that you are being sponsored by, let me say that, for example, if our department makes a false claim that we have been sponsored by, let's say, Indian Institute of Management Kashipur, for example, or let's say if I make a false claim that we have been approved by some industry body, let's say FICCI, or let's say CII, and if this claim is false, then this would be considered as unfair trade practice. So this was the provision in the Act, in 1986 Act. So naturally, if you are coming up with an advertisement, if you are coming up with an advertising campaign, so you cannot make false claims about these aspects and the other aspects as well. So this is just an indicative list, so you cannot make a false claim about sponsorship or approval. For example, you might have seen so many ads which show that they have been approved by the Indian Medical Association. Now this has got to be true. If this is a false claim, then this would be termed as an unfair trade practice. So basically what it means is that even in your advertisements you cannot make such false claims, right? Now what does the Competition Act 2002 talk about? I hope you remember that Competition Act actually succeeded the Monopolies and Restrictive Trade Practices Act, right? And Competition Act basically does what? It promotes competition. Why does it promote competition? Because more competition would reduce prices, would lead to increase in quality and reduction in prices, and consequently it would be better for the customers. It would be beneficial for the consumers. So this is why Competition Act 2002 basically promotes competition, right? And what is the provision here? Now let's have a look at the provision here. Excessive expenditure on advertising is considered anti-competitive. Now, excessive expenditure means if you are spending a little, if you are spending a little too much on advertising, then it might be considered anti-competitive. Now what does this mean? See, basically, let's say if you are a dominant player in a market, supposing you've got 50% or 60% market share, and then you are naturally, if you have this kind of market share, you will have deep pockets, you will have a lot of money, and supposing you are using this money, you are spending it so much that you are not allowing other companies' advertisements to reach the customers. So you have booked all the media spaces for yourself, you have booked all newspapers for yourself, all channels for yourself. No rival of yours is able to display his or her own products. Then this could be considered anti-competitive, because you are not allowing the competition to come up, the rivals to come up. And if there is no competition, you are the only player in the market, you are a monopoly in the market, naturally it would not be good for the consumers. And that is why Competition Act says what? It says that you cannot spend excessively on advertising, right? Now let's talk about the Drug and Magic Remedies Objectionable Advertisements Act 1954, right? Now what does Drug and Magic Remedies Act say? It says that you cannot advertise drugs for some of the maladies, some of the health disorders. What are those kind of health disorders for which you cannot advertise drug? Diabetes, heart disease, obesity, and again this is a very short list, it's an indicative list only. There are other diseases which are also included in this particular list. Sexual impotency, menstrual disorder. So you cannot come up with ads which advertise the treatment for these kind of ailments, or which advertise some drugs to treat these kind of ailments. Now, do you recall seeing any kind of ad which depicts these maladies and the treatment of these maladies? I think you would not have come across these kind of ads. Have you ever come across an ad which says that, okay, if you have this, you would not have heart disease, or let's say if you have this particular product, you can get rid of the heart disease? You would probably never have seen this kind of an ad, and the reason is this particular act. Is this fine? Now, let's talk about the Trademarks Act. I hope you know what trademarks are. Trademarks, basically, we are talking about now this. For example, let me talk about this particular thing here, or let me talk about the S in Maruti Suzuki. Now, this is a trademark. Have you seen this kind of S being shown on the bonnet of Maruti Suzuki cars? This is basically a trademark. Have you seen the nest in the Nestle products? Maggie, for example, you might have seen that particular nest and with some birds inside that nest. Now that is a trademark, right? Our college also has a trademark, right? And what is the advantage of a trademark? Trademark would help the customers recognize a particular company. You might recognize Dabur by the tree that is shown on the Dabur packaging. Now that is the Dabur trademark, right? So this is what the role of trademark is, and that is why the Trademarks Act 1999 says what? It protects registered trademarks against unauthorized use by others. So for example, if you are a company and let's say you have come up with a trademark and you decide that you will be using this particular trademark, so you have to first get it registered. Once you have got it registered, nobody else can make use of that trademark without your express permission. Now this is the meaning of unauthorized use. Nobody can use it. And now since nobody else can use it, just by looking at your trademark, your consumers, your customers can understand that, oh, this particular product belongs to this particular company, and they would purchase you. This is especially important in markets like India, where quite a significant number of people in the rural areas specifically, they are still illiterate, and many of them, they would not be able to differentiate between an actual product and a spurious one. So here the trademark becomes even more important. Is this understood? So this is what we mean by trademark, and this particular act does what? It protects your trademark against use by somebody else. Somebody else can use it as long as they have a permission from you. If they don't have that permission, they cannot use your registered trademark. But to make this happen, you have to get your trademark registered first, right? Now what will happen if somebody goes on to use your trademark without your permission? Then in that case, that particular individual, that particular entity can be punished in case they are using your trademark without your permission. And naturally they would be doing this to mislead the customer. Now have a look at these examples here. Now this is the product from the real firm, Dettol, Reckitt and Benckiser product, and now this is trying to fool the customers into believing that this is also Dettol, while the actual name, the spelling is quite different. Dettol, it has been spelled differently. Now this is basically done to mislead the customers, right? Have a look. Likewise here, this is the company, and now this is trying to mislead the customers. Now this is not allowed under the Trademarks Act 1999 also, right? Now let's talk about the Cigarette and Other Tobacco Products Act. This is also known as COTPA, C-O-T-P-A, Cigarette and Other Tobacco Products Act 2003, a very recent legislation. And what does this law say? This says that you cannot come up with advertisements for tobacco products including cigarettes. So you cannot actually advertise cigarettes and other tobacco products. And that is why you never come across a banner which is talking about any particular cigarette or tobacco product brand. Have you ever come across this kind of a hoarding, this kind of a banner or this kind of a hoarding? You would never have come across this kind of advertising going on. You would never have come across this kind of advertising campaigns. The reason is this particular act. However, there are some exceptions. So these kind of advertisements can be there on the packaging of the product itself. So the advertisement cannot be put up on a roadside hoarding. It cannot be telecasted on television also, but it can be put up on the packaging. So naturally that is perfectly fine, because by the use of packaging only you can help your customers identify yourself. So that is perfectly fine. And again, as POP display. Now what do we mean by POP? POP here means point of purchase. And what do we mean by the point of purchase? Point of purchase is when you actually go and make purchases, and that is the retail point. So you might have seen retail points. There are so many POP displays. If you go to, let's say, some kind of retail store, you would find some danglers hanging from the roof, Lifebuoy danglers or Dettol danglers, which are trying to remind you to purchase Lifebuoy or Dettol, for example. Is that okay? Or for example, you see the Pepsi fridges, the Coca-Cola fridges. This you must have seen. Now they are POP displays. Yes, they are being used to store Pepsi or Coca-Cola or other carbonated drinks, but they are also actually trying to remind the customer to buy a Pepsi or a Coca-Cola. Now this is a POP display, and the reason why you come up with these kind of POP displays is to remind the customer at the point of purchase, and that is why they are known as point of purchase displays. Just fine. So as far as cigarette and other tobacco products are concerned, they can be advertised on the packaging and as POP display, which means at the retail point they can be advertised. And that is why you might have come across such panwadis, pan shop walas, wherein the hoarding is depicting a particular cigarette ad. But otherwise, on the roadside, you would never have seen this kind of a advertising campaign going on. Is this fine? So this is what the Cigarette and Other Tobacco Product Act 2003 prohibits. However, you should also understand that there are other provisions also in this particular act. One of the provision is that within a particular distance of an educational institution, you cannot sell these kind of products. So this is another provision which is there, and that is why nowadays you see that within a particular distance from a school or from a college, you cannot put up a shop which is actually selling tobacco products. So this is another provision of this particular act, right? Now let us talk about the Cable Television Networks Act 1995. So cable television actually came in India. This was the time when actually Cable Television Act was being television networks were introduced here in India. That was around 1994-95, and that was why this particular act came, which tried to regulate this particular market. So in the Cable Television Network Act, there is a prohibition, and the 2000 amendment does what? So it was amended in 2000, and there's a provision in this particular amendment. And what is that provision? It bans the advertisements of some specific category of products, some specific categories of products. So cigarette and tobacco products. So you cannot advertise cigarettes and tobacco products on television, on the cable network. Likewise, alcohol, liquor and other intoxicants, right? So they also cannot be advertised. And let's talk about the infant milk substitutes foods. Now you can understand very well why they are not allowed to be advertised, cigarettes and tobacco products, the alcohol, liquor and other intoxicants. But why on earth are you stopping the marketers to advertise their infant, newborn baby milk substitutes or foods? The reason is very simple, because at that point of time it was thought that if these kind of ads are allowed, what might happen? Mothers might stop breastfeeding their babies and instead start feeding their babies on milk substitutes. For example, you might have come across products like milk powder or something of that sort. So they are milk substitutes. However, these milk substitutes are not good for the baby. So it was thought that it was thought at that point of time that such products should not be allowed to advertise. Otherwise, the consumers may be misled. The mothers may be misled into believing that these milk substitutes are good for their babies, which is not the case. Now, this is one thing that you should remember, right? Now, I hope you understand and you remember what the companies have been doing, what the marketers have been doing to go to somehow get around this particular provision. Now, they cannot advertise cigarette and tobacco products. They cannot advertise alcohol, liquor and other intoxicants. Do you remember what the marketers do? I hope you remember our discussion about the surrogate products, surrogate advertising, in the last session. Please go through that video lecture again and you will understand that nowadays marketers have come up with this kind of surrogate advertising campaigns to sell their alcohol or to sell their tobacco products. I gave you an example there, the McDowell soda, which is basically a surrogate advertising campaign for the McDowell whiskey. Likewise, we have got Kingfisher, we have got so many such examples, right? Now let's talk about the Advertising Standards Council of India. So basically, I hope you understand that this council is this council is doing what? It is basically setting standards for the advertising world. Now please understand, this is self-regulating body. Now what do we mean by a self-regulating body? This is a body which is meant for regulating their own affairs. Voluntarily set up body, and this body has been set up by the various stakeholders in the advertising world, which include the media, which include the people from the advertising world, advertising agencies, and there are some people in this body who also represent the consumers. So this body has been formed by the advertising world, by the advertising the various entities, various advertising agencies on their own to regulate their own affairs, to ensure that advertising is not misleading. So that is why it's being termed as a self-regulatory body. So it would be setting up some standards, and these standards will have to be followed by the various media agencies, various advertising agencies also. So it basically does what? It actually writes these standards so that they are then further followed by these entities, be it the media, be it the advertising agencies, right? And what are the various provisions? What are the various standards? Let's have a look. The code of self-regulation is there, code for self-regulation, which says that the advertising campaign should be truthful. The claims that you are making, they should not be false, they should not be misleading claims. They should be truthful. Prohibits advertisements which are against generally accepted standards of public decency. So it also prohibits those ads which are indecent in nature, for example, which depict nudity. We have taken up this example right now, a little while ago, in the beginning of the session, where I talked about the tough shoes and the ad that was depicting the two models not at all wearing anything. So if the ad is against the generally accepted standards of public decency, what do we mean by this? What is considered decent by the society and what is not considered decent by the society? So generally accepted standard means from the societal aspect. Now what do we mean by this? Now please understand. For example, a little bit of nudity would be okay in the Western societies. It would be considered okay by the Western societies, but that may not be the case here with our society, which is more conservative in nature. So while A little bit of nudity if depicted in an ad in USA would be perfectly fine. The same ad would not be considered okay here in India. So that is what we mean by generally accepted standards of public decency. What are the social rules? What are the social norms about what is decent and what is not decent? For example, right? For example, if you go to a beach, if a girl or if a woman goes to a beach clad in bikini, it may not be considered okay here in India, but that would be perfectly fine in some Western society. So that is what I mean by generally accepted standards of public decency. So the ads should not be against these standards. They should not be indecent with respect to the standards in that particular society. So for example, Indian society, as I said, is a little conservative. So here we have to ensure that whatever we are depicting, it should not be indecent as far as the standards here in Indian society is concerned. The standards here in Indian society are concerned. Now again, another provision is indiscriminate use of advertising to promote products which are harmful for society or particularly for minors. Minors is less than 18. So you cannot, indiscriminately means without thinking, come up with advertising campaign which are selling products which might be harmful for the society, which are not good for the society, and specifically for those who are less than 18 years of age. Why this special protection provided to the minors? The reason is those who are less than 18 years of age, it is considered that they would not be able to differentiate between what is a right course of action and what is not a right course of action. They do not know, they don't have the capability to take the right decision. So naturally, if you are coming up with a product which is not good for these minors, and somehow these minors are getting exposed to that kind of advertising campaign, they might still purchase that particular product, though it might be harmful for them. So we are trying to protect the society and specifically the minors from this kind of promotion, this kind of advertising campaigns, right? Now another provision is, now please understand, I hope you remember, a marketer commissions an ad. For example, I am Department of Business Administration. I'll commission an ad, then an advertising agency will design the ad for me, and then that particular advertising agency will place it in a media. It could be the Star TV, it could be the GTV, it could be the Amar Ujala newspaper. So basically there are three entities which are involved. One is the marketer himself or herself, then we have got the advertising agency which will be actually designing the ad, and then they will be shooting the ad in case of a television ad, and then the ads have to be placed in the media. So basically three different entities are involved, and now this particular code makes it incumbent on all these entities, the advertisers, the marketers, the agencies, as well as the media, not to create or place, publish or commission any advertisement in contravention of this code. So any advertisement which goes against this code, which contravenes this code, which violates this code, this kind of an advertising campaign cannot be run. And for this, the responsibility is not only of the advertisers but also of the agencies and also of the media. So even if an advertiser has commissioned this kind of an ad, they've ordered an agency to come up with this kind of an ad, this agency now is also responsible to ensure that they do not design such ad. Again, let's say the advertiser has come up with these kind of ads. They want these kind of ads to be made which are violating these codes. The agencies are also complying with their directions, and the advertising agency have come up with this kind of an ad. Now it is the responsibility of the media not to allow such ads to be displayed. So they would not sell ad space to such kind of advertising campaigns. So the responsibility falls on the shoulders of all the three entities: It is not just the responsibility of the marketer or the advertising agency or the media. It is the responsibility of all the three entities. And this is to ensure that such kind of ads are not actually broadcasted or displayed. This is fine. Now please understand, who will create the ad? The agencies will create the ad. Who will place it? The agencies will place it. Who will publish it? The media will publish it, right? And who will commission it? Commission means who will order that particular advertising campaign? The marketer or the advertiser. And that is why we are using all the four words here, right? So advertisers cannot commission, should not commission, agencies should not create or place, and media should not publish these kind of advertising campaigns. Now let us talk about the Consumer Complaints Council, which is part of this Advertising Standards Council of India, ASCI. Now, what if a particular advertiser or an agency has actually come up with an advertising campaign which violates these provisions? Now for that we have got the Consumer Complaints Council. It will do what? It will examine the complaints which are received from the general public. So for example, if you are aggrieved, you have read the whole code, Advertising Standards Council of India's Code for Self-Regulation, and you feel that a particular advertising campaign violates a particular provision of the code. Now what option do you have? What alternative do you have? What recourse do you have? You can actually lodge a complaint against that particular advertising campaign, and you lodge that complaint with the Consumer Complaints Council. And then this complaint would be examined by the council, and then based on their examination, based on their investigation, they may order, if they come to the conclusion that a particular advertising campaign against which you have lodged a complaint, it actually violates the code, then what they can do is they can order the withdrawal of that campaign altogether, which means they would not allow it to be displayed further, to be broadcasted further, complete withdrawal, or a slight modification of that particular advertisement or of that particular advertising campaign. So this is the power that Consumer Complaints Council has. Now please understand that I have given you a list of the projects that you can do as part of this particular course, and for that particular list you will have to go to my lecture plan, which I have posted right in the beginning of the semester, somewhere around 14th of August. Now what you have to do is, you please have a look at the list and you please start making up your mind as to which particular project you would want to do. Within that particular list you would find a particular project which has relation to whatever we have discussed today. In fact, in that particular project, what you have to do is you have to spot any advertising campaign which you feel goes against, which you feel violates the code for self-regulation, and then you have to basically lodge a complaint and to ensure that some action is taken by the Consumer Complaints Council. So I would advise whosoever wants to do that particular project, whichever group or let's say whichever individual wants to do that particular project, you have to do that individually. That particular individual should start working on that project right now, right away. Fine, because this is going to take some time. You will be lodging a complaint, and then the complaint would be heard, and then there would be a decision made. There would be a ruling given by the Consumer Complaints Council, so that is naturally going to take time. So if you are able to get a favorable decision from Consumer Complaints Council, then only you will get 5 out of 5. Is this fine? So you start working on that in case you are willing to do that particular project, right? With this discussion, now I have wrapped up this session on the legal aspects, and we also happen to wrap up the unit 1 today. Now, as I told you earlier also, there would be an assessment test once the unit is over, And now this is the Google Classroom link for this assessment test. You can have a look at the code, and you please start joining this particular class, which has already been created, advertising and sales management. You can have a look here also. So you please start joining this class, and the assessment test would take place on Tuesday. The schedule that has been given is that my lectures will have to go live at 11 a.m. So likewise the test would also be conducted at 11 a.m. So you please join this particular class and then be ready to take that assessment at 11 a.m. on Tuesday. That is probably 25th of August. Right? So this is what you'll have to do. No separate announcements would be made by me. Fine. So thank you very much for your time, and please understand that the questions that would be there in the assessment test, they would be in the nature of they would be more uh, application oriented in the nature. So rather than just cramming up the theory, because I have come across students who tend to make their notes and then they've been copying those notes while answering the questions in the assessment test. So the paper that I'll be giving you would be more application based. So rather than cramming the notes, it is better that you understand what is being discussed in the class, what has been discussed in the class, and then prepare yourself to be able to apply those concepts, right? So thank you very much for your time.